Hi everyone, Mario Quintero here with the One Stop Shop, produced by marioshomenews.com. This week, I'm very happy to introduce to you, not only is he a personal friend, but he's also one of the best estate planning attorneys that you're ever going to find. Peter Ariz, thanks for joining us here today.
Mario, thank you for the invite. I'm always a big admirer of yours, and we've worked together on very challenging matters over the years, and I've always gained a great respect for your professionalism.
Thank you.
And the manner in which you conduct business.
Thank you.
I'm honored to be your partner.
Thank you, and I'm honored to be having the opportunity to work with you on so many different cases, and you've done a great job. So Peter, why don't you tell us a little bit about specifically what you do?
Well, Mario, I have been an estate planning attorney for, it's kind of scary, almost 30 years, and so what I do is I plan people's future. And we also, when people don't plan their future, we end up going to court for probates and guardianships when you have situations where a person is incapacitated and they need to have a guardian named to take care of their finances and personal matters.
So one of the reasons I asked Peter to come by today is because in the real estate world, in the finance world, in everyday living, we really put estate planning as one of the last things or priorities in our lives. And I'm really happy he's here today because I want to know if you could explain to our viewers, what does an estate planning attorney really do?
Yes, that's a great question, by the way. Thank you. The estate planning attorney sits with you and talks to you about what you have, what assets you have. Estate planning is all about court avoidance, I always say. When I started practice 30 years plus, the number one question that people had then was, I want a plan so I don't have to pay taxes, because believe it or not, back then, the allowable amount of money that you could give to your heirs was $60,000. So you were going to be taxed at close to 50% of any amount over $60,000 that you gave your heirs. So it was a very scary proposition for people, and they really needed to sit down and plan ways in which they could ameliorate or reduce that tax liability. That's what people came to me for. Back in the 90s and at the turn of this century, people came to me because, for example, professionals that were uninsured, if you were a doctor, a surgeon, and you were uninsured, then you needed protection, so you used the trust and estate plan as a form of protection. And finally now that thanks to the last few presidents that we have had, we have we can give our heirs over $5 million and change tax-free. So for most people and couples, that's doubling now. But that is not a concern for most people. Most people have less than $5 and $10 million, and so basically it's not an issue. What people come to me for today, Mario, is how do I avoid the court system, which has become a very expensive way of inheriting property because of all the issues that come up. And we'll talk about them a little bit later.
Okay. What is an actual estate plan?
An estate plan for me, for Ariz law, concerns of the following. Number one, the centerpiece of an estate plan is a revocable trust. I say revocable because I get this question all the time. Is it a revocable trust or an irrevocable? An irrevocable trust is a trust that you make that you can't change ever. So a revocable trust is one that you can make amendments on, which I think is a much more practical and effective document. But what it is, it basically states three players, and the players are the trust, the creator of the trust, which is usually the person that comes to me and asks me to do a trust, the trustee, which is usually that person, which is the overseer of the trust, and the beneficiary, which is also usually that person. Now, after that person comes a successor trustee and a successor beneficiary, or trustees and beneficiaries. And the beauty about a trust is that the inheritance and how that person wants his heirs to receive the property is laid out beautifully and in complete detail in that trust document. The trust document ranges from 20 to 30 pages depending on the complexity and the things that you want on there, but you can make specific requests. If you have a particular piece of property that you wanted to give to a child, you could say, I want the property located at such and such address to be given to this child if I own the property at the time of my death. So you've given a child or a friend or whoever you wanted to a particular piece. You also could have the residuary estate, which means that whatever you have left is divided among your heirs, usually in equal shares, sometimes not. If you want to give somebody,
You could specify the percentage that each person would get.
you could specify the percentage that each person would get. If you have 3 children, you could say 33 and a third goes to this child, 33 and a third to this child, and so on. If you want to give a special gift to a grandchild, you may say, I want, little Bobby to have $10,000 at the time of my death if I have that money. And so we put that in the trust. So the trust is the centerpiece which dictates how your inheritance should go. The beauty of the trust is that it's a separate document that sits by itself, very much like a corporation, so it survives you. So whatever happens to you, that trust is, I call it multi-generational, because it affects your children, your grandchildren, and maybe the children after that. It's a wonderful document that basically leaves your desires in writing. And that trust, which acts like this umbrella over your assets, hopefully will own your assets, all of your assets, either directly, meaning your home where you live could be owned by your trust and you get the same homestead benefits that you have as an individual, or you could own it indirectly. So if you own real estate, you could own the real estate through limited liability corporations whose shares are owned by the trust. It's a complex thing. We can talk about it when you see me, but basically that's the trust. I also provide a pour-over will. It means that if you forgot to add anything, the pour-over will picks it up and throws it into the trust. I always really stress, let's not forget any assets, and let's put all the assets into the trust. Investment accounts, savings, CDs, because if you forget it, the bank is going to, at the person's death, is going to say, you need to go to court and get us a court order so we can give you this money. You don't want to do that because that becomes a very expensive process. So I've given you, with a estate plan, a trust, a pour-over will. I also provide a power of attorney, which is very effective, not as effective as it used to be. Banks don't take them as much as they used to, but it's still effective, because if you're out of the country, you may want to pretend you need to sign a document, closing or things like that. You can use the power of attorney to help you achieve that without you getting in a plane and having to rush back to town to do what you have to do. I provide 2 critical documents for hospitals. Living will, which states, if you were in a state which was a state, an end state or a terminal condition from which you're not going to recover, how you would want to die. That's the living will. And then a second one that I just added over the last couple of years, which is a designation of healthcare surrogate. I always feel that's a very important document, because when you walk into a hospital, by and large, the hospital will hand you paperwork that's very similar to this. But the hospital usually takes control over your decision making, and you do not want anybody but those that you love, those that you trust, to make those decisions for you if you're not able to do that for yourself. So it's critical that you have these 2 documents, because any one of us can at any time can end up in a hospital, and we want to have those 2 documents with us when we end up there.
I'm very grateful personally, because my parents took the time to do all of these documents, and when my mom was near death, I went to the hospital with all the documents that she had prepared, and they had to listen to what the wishes were of my brothers, my sister, and myself, because my mom, both my parents, had spelled out exactly what they wanted regarding quality of life.
I know it.
And she emphasized that the day that she did not have any quality of life, that's when we needed to make a decision on her behalf, which we did. And having those documents made the process a little bit easier, because if you don't have those documents, the hospital's job is to keep them alive.
That's true, and sometimes to actually not, and that's an issue too, because once that person, say somebody comes into a hospital, I just went through that recently with a close friend, when the person has a heart attack and is brain dead, at that point the hospital wants the family to make a decision to disconnect that person. And it becomes a very stressful situation for the family when they're getting pressure from the hospital to do what they feel they need to do to move that person out of that ICU room. So it's a challenge. The living will situation, I always say it's really done for the children or the heirs, because nobody wants to sit at a bedside of a parent or a grandparent or someone that cares for you and make the decision of whether to keep that person alive or disconnect that person from any life prolonging equipment or procedures. And to me, by writing that, it shows your kindness to your heirs, to people that you care for. So that's a really critical document. I also do an assignment document, Mario, which assigns all your personal property to the trust.
Okay.
That's a great way of, for example, when you have vehicles in your name, when the person passes, you can go to the tag agency and actually transfer title to whoever would buy the car through that assignment and the trust.
So Peter, we're halfway through the questions and you've given a bunch of information here. If any of our viewers want to get in touch with you to have a consultation with you, what is the best number for them to reach you?
Mario, they can reach me at 305-859-9898. Our offices are on Coral Way, 2103 Coral Way, Suite 800, Miami, Florida. But if you call our number, 305-859-9898, we will take your call and set up an appointment for you. The visit is free, so you can come in and we can talk about what your concerns are and whatever issues you may have. We'll be glad to help you or at least give you some options.
So we're halfway through the questions. Now we're going to get into some more specific questions. And, you know, if you've been putting off this type of planning for yourself, for your heirs, for your family, listen to these next answers, because it may actually make you pick up the phone and call Peter for some assistance. So, Peter, is a will enough? If just having a will, I know I have a lot of clients that come in and they say, well, I have a will. Is that enough?
Well, that's a great question, Mario, and I'll tell you why. And you and I know this because we've been through this matter together on a number of occasions through the years. A will is great in the sense that you have put in writing what you desire will go to somebody. So you can say, I want so-and-so to go to my child. I want so-and-so to go to this person. That's fine. But it does not keep you out of court. A will is a document that states the person's intentions at death. But now, once that person dies, now you have to go to court. You have to prove that the will is valid. It has to be properly written. It has to be properly witnessed and notarized. It has to be valid. And the judge certifies that will to be. So you have to have an original will. It's a lot more difficult without an original will. But assuming you have an original will and you file it, now you have to open a probate. Probates have become much more expensive than they used to be. The process has become a long and tedious process. We have really good judges down here in South Florida, but the amount of cases that these judges have is the volume of cases is huge. So where in the older days you used to go and get a hearing really quickly, it'll take you months to get a hearing for anything now. So the process becomes much more expensive, longer. You also are prone to having creditors come in. I'll tell you a funny story in a minute about that, but basically once the probate is filed and published, notices of the probate are published, then creditors have up to 90 days to actually file a claim. Well, one of the things that we've been experiencing the last few years is the state of Florida, Medicaid, is coming in and putting claims on estates. For anybody who had received Medicaid, the state of Florida has a right to come back and collect it. Wow. And they do it from the estate. Now, if you had a trust and all your assets were in a trust, and the property and the assets, property or money or whatever passed through the trust, you would never see a court and nobody would ever know. But once you have to go through probate, now the claims come. And you could have It's happened to me where I created a trust and somebody's come to me and says, Dad had a $30,000, credit card that he owed money on. And I said, well, did you owe the money? Is your credit card, was your credit used? No, it was just Dad's. I said, well, they can't claim it against you.
That's considered unsecured debt.
It's unsecured debt. They can't claim it against you. But that unsecured debt allows it in a probate. The credit card company can come right up and say, we need to get paid. And now you got to deal with that debt. So it becomes a really extremely expensive process in many ways, not just legal fees and court costs and the time that it takes. It can take, it used to be that you could, within 3 or 4 months after the opening of probate, you close it. I can't say that's the case today because there's so many complications and things that happen. This is on a straight, easy type of probate.
So it's either you pay some fees now
Right.
to get everything in order, or pay a lot later to fix it.
And the fees now are nothing compared
To what it's gonna
you're
be
gonna
later.
pay just to get the probate open.
Well, we were involved in a case together that could have been completely avoided, where the legal fees, I think if I recall, were $180,000 split by the two sides of the attorneys. And you were involved in the probate part of that with a litigation attorney, and the other side had a probate attorney and a litigation attorney, and the family, for lack of planning, blew $180,000 in legal fees.
I'm going to tell you something. I love those type of cases. You do not want to be involved in that kind of case where the attorney's smiling about the fee. What you really want, and this is what I'm here to do, I don't want those fees. I really want to plan your future so you can avoid those fees. Yeah. This is what this is about. It's about safe planning, doing it right, doing it very economically, very efficiently, very effectively, and allowing you to grow with that, because these documents are all irrevocable, which means that if something happened or there was a change of mind or something, you could do that. Let me give you an example, Mario. If you had children, small children, what have you made provisions if you have small children of what would happen if both parents passed? Who's going to take care of that child? Who's that child going to live with? And who is going to take care of the finances of the money that you've left that child behind? Who's going to do that? If that's not spelled out in writing, you're doing your family a disservice on a basic level. I use the pour over will as my instrument where I mention all these things, including who would take care of those things, because that way you can leave in writing your desires and wishes as to who you would trust with your children.
Let me ask you a quick question. If you have all these